Thank you, everyone. Before we proceed, we would like to remind everyone to keep your audio on mute and your video turned off. If you have questions, you may click the Q&A tab button found in the participants section of the app. There will be time allotted for Q&A at the latter part of the session. Good afternoon once again to all of you. I'm Jennifer Mosso from Rex Bookstore, and I will be your host this afternoon. I hope everyone is safe, healthy, and in good spirits. Now, to officially open today's event, let us hear from Rex Bookstore's Chief External Affairs Officer, Ms. Danda Cremelda I. Buhain, for her opening remarks and message from the publisher.
Good afternoon, our dear guests. Thank you for joining us as we celebrate our very first book launch this 2021. The year we have unveiled ourselves as the new Rex Education. With 70 years of service and dedication to education, Rex now evolves from that iconic bookstore that we all know to something bigger and more significant. We are now Rex Education, a brand, a community, an advocacy, a tradition of service dedicated to inspiring every Filipino lifelong learners to advance themselves and uplift others. We have gone from just providing learners with published materials to accompanying them through their lifelong journey. Learning in all forms, beyond the walls of institutions, learning for delight and enlightenment and fulfillment. This afternoon, our tradition of service continues as we launch yet another worthy addition to our unparalleled suite of legal publications.
Yung kulay pula na makapal.
The highly anticipated new edition of the Revised Penal Code, Book 1, by highly acclaimed criminal law Rex author and bar reviewer, Judge Marlo Campanilla. Allow us to take this opportunity to honor the inspiring journey of Judge Campanilla, now a staple authority in the sphere of criminal law. He started his career as a practicing lawyer in 1995 and was appointed as one of the youngest city prosecutor of the city of Manila. Now a renowned author of criminal law books, Judge Campanilla, through his years of work and experience, has sharpened his gift to navigate through the intricacies of criminal law, reflected thoroughly and expertly in his books. His passion is not only seen through his books, but also in his bar review lectures, in major review centers and premier law schools, all throughout the country, and which we have proven to effectively enable bar takers to hurdle criminal law bar questions. As we will see this afternoon, a multitude of learners attest to how his books were highly instrumental in achieving their dreams of passing the bar and becoming lawyers. For embodying Rex Education's thrust in championing education, allow me to thank you, Judge Campanilla, for our shared commitment to work for the best interest of Filipino law students and lawyers. A true educampion, friends, ladies and gentlemen, let us all welcome Judge Marlo B. Campanilla.
Ano ba? Sorry
Yes, Judge.
Yes, sir.
Pasensya na po pasensya na. Alam mo yung Rex Bookstore dati kariton lang yan eh.
Opo.
Grabe. Oo. Mahirap lang sila.
Opo.
Balita ko. Pero ang Rex ngayon, bilyonaryo na.
Hindi ho totoo.
In fact, mas kumikita sila sa sa high school tsaka sa elementary. Itong College of Law maliit ang kita nila rito, pero they are maintaining this business in selling law books kasi dito sila nag-start sa sa law books. Pero ang kita nila ngayon sa ibang libro na. Pero grabe. Bumulusok ang Rex. Bago ako mag-lecture yung unang Actually, yung unang book ko is Constitution. Yung second book ko, Revised Penal Code with Annotation 2004. I have to admit at that time that I wrote that book, I'm not yet an expert. Pero ang ginawa ko, binasa ko lang. Binasa ko yung Regalado, Aquino, Kapunan, Guevara, Albert, lahat yan. Binasa ko yan. Francisco. Tapos lahat ng mga Supreme Court decision binasa ko. Tapos I produced that Revised Penal Code, Book 1. 2004, pinpublish ng Rex yan eh. Masyado siyang bulky. Ako, I have to be frank that that book is not a, hindi siya ganun ka-successful. Hindi ko na siya na-update kasi nagsulat na ako ng special penal laws, maraming mga libro, nag-lecture, masyado na ako naging busy. In fact, yung dati pa lang, maaga pa lang, pinipressure na ako ng Rex na to update the book. Kaso hindi ko naman magawa. Agad sa nakaproduce ako ng reviewer. Doon ako ayun ang bementa ng maayos, no? Itong book na to, medyo mas bulky kasi yung dating libro eh. Napapansin ko ayaw ng mga estudyante na masyadong makapal. At saka, kung i-compare, marami rito siguro nabasa na yung reviewer ko. Ito, iba yung sa reviewer, ito to kasi iba naman to kasi yung sa reviewer, highly yung discussion yun, talaga eh. Yung correlations niya masyado ng malalim. Kasi pag magbabar ka na doon eh. Pero ito, ang ginawa ko, ina-avoid ko muna yung correlation. Magko-correlate lang ako. Halimbawa, nasa isang provision na ako, pwede ako mag-correlate pabalik. Pero pag halimbawa, nasa book Article 2 ako, hindi ako magko-correlate ng papalayo eh. Kasi mahihirapan yung mga estudyante. Lalo siyempre mga first year pa lang yan eh. So, kaya iniingatan ko na hindi sa maging complicated, sinisimplify ko siya. Tapos, sorry, nagalaw. At saka yun, updated. Medyo, alam mo, ang criminal law, hindi na, kada taon nagde-develop siya eh. May mga bagong batas, may mga bagong jurisprudence, yung mga principles bigla na lang ina-abandon o minomodify, kaya napaka-complicated, no? Tapos may lecture ako sa March ha. Yun, online, may bayad po yan. Sana i-follow nyo ako sa Facebook ko, meron akong page account, Marlo Campanilla, type nyo lang, lalabas na yon. I-announce ko yung lecture ko. That is 7 days lecture para sa mga magbabar. At very comprehensive siya, tsaka comprehensive and selective, no? Para makita nyo talaga yung talent. Yung talent ko, no? Siyempre, kahit paano meron naman akong unting talent, no? So mag-lecture tayo ng kaperaso, isang oras, tapos mamaya may mga yung iba rito, I understand that andito sila para pakinggan yung lecture ko. Pero pag nag-testimonial naman yung meron tayong mga top-notcher na magti-testimonial, wag nyo naman na pagkatapos yung pakinggan yung lecture ko wag nyo nang pakinggan. wala namang gano'n. So, kung pwede lang naman ha, pagkatapos ko mag-lecture, may testimonial. Kasi actually, this is a combination of the launching of my book and free lecture na yon. Magkaroon tayo ng unting lecture. Maiksi no? At 1 hour. Tapos mag-open forum tayo. Ha? Open forum. So, meron kasi akong gustong i-lecture This is the case of reside. Ewan ko kung reside ang pagka-spelling niya, reside hindi ko alam ang pronunciation nito, either reside or reside versus people. At this is 2000 to 2020 at parang July 28, 2000 2020, no? Latest siya. Pero bago 'yan, mag-ano muna ako, magpi-preliminary muna ako, no? Kasi this case is very interesting kasi this is a modification of the case of yung Chua Borse. Yan eh. Yung Chua Borse, matatag na principle yan eh. Kaso nagkaroon siya ng tawag dito ng modification. So ano muna tayo ha? Magpe-preliminary muna tayo bago tayo pupunta sa case of Reside versus people. No? So yung ano muna yung ano ba yung pagkakaiba ng estafa through misappropriation sa theft? Basic naman yan. Siyempre ang theft, that is taking property without the consent of the owner. Yung estafa naman, that is receiving the property, trust, commission, administration, no, at obligation involving the duty to make delivery or return. No? But later on, nagkaroon ng misappropriation, denial, conversion. Pero may mga occasion that the accused received the property with the consent of the owner. But the crime committed is theft or estafa depending upon the character of the possession. If the possession is juridical or de jure, so misappropriation, conversion, that is estafa. On the other hand, if the possession is physical or de facto, misappropriation shall be considered as taking without consent, and therefore the crime committed is theft. So in other words, if the accused received the property with the consent of the owner, and he acquired physical or de facto possession in doing so, na misappropriation of the property or failure to return or running away shall be considered as taking without consent, and therefore the crime committed is theft. At on the other hand, if he received the property with the consent of the owner, and he acquired juridical or legal possession in doing so by reason of administration, trust, commission, or obligation involving the duty to make delivery or return, misappropriation, conversion shall be considered as estafa. For example, in the case of U.S. versus De Vera, this is year number 16961, September 9, 1921. No? Ito yung nung kinuha niya yung property from the Igorot, dadalhin niya sa goldsmith for examination. Baka hindi kunto yan eh. Ipa-check muna natin sa goldsmith. No? So, sige, binigay sa kanya. So in other words, he received the property with the consent of the owner. No? May consent yun eh. Tapos hindi niya sinole. Pero i-modify ko na lang yung facts para medyo mas maganda ha. Dito sa US versus De Vera, hindi niya sinole. Pagkatanggap niya yung property, bigla siyang tumakbo. No? Bigla siyang tumakbo, nagtatakbo siya. So what is the crime committed? Kung mapapansin niyo dito, yung taking niya, no, yung taking niya merong may consent, 'di ba? Yung taking niya may consent. No? May consent yung taking niya, kung mapapansin niyo. dalhin ko sa Goldsmith, no? Pero yung failure to return or yung immediately run away, pag i-exaggerate ko na lang. Pagkatanggap niya, dalhin ko sa Goldsmith, bigla siya nagtatakbo, no? That failure to return or running away shall be considered as taking without consent. And therefore, the crime committed is estapa. The crime committed is theft, not estapa. So in other words, the crime of theft happens not at the time that he received the property with the consent of the owner. May consent kasi yun eh. Tinanggap niya, may consent, di ba? So that is, kasi di ba ang theft taking without consent, ito receiving with consent. So the act of receiving with consent, that is not theft. But the act of running away or failure to return, taking into consideration that his possession is merely physical, shall be treated as, no? Yung running away at failure to return shall be considered as taking without consent. And therefore, the crime committed is theft. So yung theft nangyari yan, not at the time that he received the property, but at the time na he failed to return or he suddenly ran away. Theft siya. Now, merong isang kaso, dati kasi, yung pagkakaiba ng estapa at theft, hindi siya ganun kalinaw. Ang mga Supreme Court decision, hindi consistent ang mga Supreme Court decision. Pero, buti na lang dumating yung Chua Borse, no? This is Chua Borse, GR number 109595 at April 27, year 2000. Yung year 2000 na-settle na kasi yung dumating yung Chua Borse, ito na palagi ginagamit ng Supreme Court. Ha? Year 2000 to, ha? Pero ito na palagi ginagamit ng Supreme Court. Ang question rito, halimbawa empleyado siya. Kasi ang empleyado, siyempre may mga property yan na yung company na accessible to the employee. No? Kasi yung Chua Borse, ano yan eh, vault custodian na accessible sa kanya. He was charged of estapa eh. No? Pero what is the crime committed? Estapa ba? Empleyado siya? No? Yun ang tanong dyan. Ganito sinabi ng Supreme Court. Ganito nang sinasa sa Chua Borse. He distinguished the case of De Guzman. No? De Guzman and Locson. Dito muna tayo sa Guzman. At itong Guzman case. So in the GR number na 9572 eh, parang October 18. Guzman, October 18 to. Kalimutan ko yung kung anong year, na? So in the case of Guzman, ganito yon. He is an agent. Hindi niya ang obligasyon niya is to sell the property with kung mabenta niya, bibigyan niya yung proceeds. Pag hindi niya mabenta, sosolo niya yung goods. Nawala na siya, no? He did not perform his obligation. No? So according to the Supreme Court, because of Article 1916 of the Civil Code, according to the Supreme Court, an agent has an independent and autonomous right to retain the property that he received by reason of agency to the extent of reimbursing himself to the expenses that he made, the damage that he suffered. Na? Kaya ang sabi ng Supreme Court is that ang possession niya because of Article 1916 of the Civil Code is juridical, and therefore misappropriation of the property is considered as estapa. Pero distinguish na Supreme Court, Chua Borse pa din to, itong Guzman sa kaso ng ng Lukson. No? Yung Lukson, ano yan eh, at 36581. Ito yung ano eh. Ito yung October, I'm sorry, ito yung October 18, 1932. Na? 1932. Now, ngayon yung sa Lukson case, bank bank teller. Alam mo sinabi ng Supreme Court. Kasi yung bank teller, he received the money from the depositor as deposit. Hindi niya na binigay sa bangko. Winaldas niya na. So sabi ng Supreme Court, at the time that he received the property, he merely acquired physical possession while the bank acquired juridical possession. Na? In fact, although hindi na sinabi ng Supreme Court, pero ako dadagdagan ko na lang. The bank will not merely acquire juridical possession but also ownership. Bakit? Lilis lang muna tayo. Babalik tayo sa Lukson. Lilis muna tayo. Alam mo ano ba yung relationship ng depositor tsaka bank? No? Kasi, di ba pag deposit, di ba comodatum yan? Pero hindi siya yung word na deposit, that is a wrong description of the transaction. Bakit? Kasi the relationship of the bank and the depositor is creditor-debtor relationship. Ang creditor yung nag-deposit, ang debtor yung bangko. Bakit? Ang relationship nila is loan or mutum. Bakit? Kasi the bank will acquire ownership eh. Kaya nga pag nag-deposit ka after a month, i-withdraw mo yung pera mo. The bank has no obligation to return to you the very money that you deposited with the same serial number. Kasi yung perang dineposit mo, mapupunta sa bangko, siya na may-ari yun. Pag withdraw mo yan, a different money will be given to you. And that is the reason why na hindi talaga sa deposit. Kasi pag sinabi mo deposit, dapat kung ano yung dineposito mo, yun din ang isusole. No? So, balik tayo sa Lukson. So yung depositor, once he deposit money, the bank will acquire juridical possession and ownership. Yung ano naman, yung yung bank teller, physical possession lang. So pag misappropriate niya yan, the crime committed is not estafa, but qualified theft. No? Qualified theft po. Kasi halimbawa ganito, meron kang sekretarya o dali mo muna tong laptop sa bahay mo. Doon mo na gawin yung trabaho. Pagdating mo sa bahay, tinawagan mo yung kapitbahay mo. Naku, may laptop dito, bilhin mo na. Binili ng kapitbahay mo. So what is the crime committed? No? Kasi the possession of the employee, the secretary, is merely physical. De facto. By selling the property, that is considered as taking without consent. So the theft happens not at the time that he received the laptop from the company. Kasi he received the laptop from the company with consent. Ang theft, taking without consent eh. So the theft happens at the time na binenta niya. So that selling will be considered as taking without consent. So the crime committed is qualified theft. That is the case of Lukson, cited in the case of Chua Borse. So in the case of Chua Borse, sinad siya ng estafa, empleyado siya. Sabi ng Supreme Court, may problema to. Why? Kasi his possession is physical. He's just an employee. The crime should have been, the crime for which he was charged should have been theft. So inacquit siya. Sabi ng Supreme Court, juridical possession is an indispensable element. Indispensable element of theft. indispensable element of estapa. Now, punta na naman tayo dito in the case of reside versus people. This is yung latest Supreme Court decision. Yung GR number nito parang 2210318. Yung 2002 parang July 28, paka-double check na lang. 2020, latest Supreme Court decision. So, principal siya tuition fee. No? So, sabi ng Supreme Court, he is just an employee. So, his possession is physical. So, the crime committed is theft. The Supreme Court reaffirmed that Chua Borse, Locson, saka De Guzman. Nila-affirm. Kaso, in-apply na Supreme Court yung variance rule. Ano ibig sabihin yon? Ang charge sa kanya is estapa, but kasi may tinatawag na variance rule eh. If the crime charge varies with the crime proven by evidence, no? You can convict the accused of the crime charged or proven as long as yung merong identity. For example, the crime proven is necessarily included in the crime charge. So, ang charge sa kanya, estapa, he was convicted of qualified theft. This is a modification of the Chua Borse. Bakit? Kasi, basahin mo yung Chua Borse at saka yung reside. Parehas yung facts in the sense that in both cases, the accused, empleyado. In both cases, the crime should have been theft, not estapa. In both cases, ang charge sa akusado is estapa, hindi theft. Mali yung charge eh. Pero doon sa Chua Borse, inacquit siya. The Supreme Court did not apply the variance rule. Pero dito sa reside, in-apply yung variance rule. So this is a modification ng Chua Borse, no? Ang Chua Borse, kasi alam mo ang Chua Borse cannot be abandoned by the Supreme Court kung hindi sa sitting en banc. Pero for purposes of the bar examination, we just follow reside. Let the Supreme Court later on in the future to make a ruling that what is controlling is the Chua Borse. Pero kasi this is latest po yan eh. Alam mo ang problema kasi pag halimbawa sa bar examination, lang naman sabihin mo na Chua Borse is controlling. Latest to eh. Yung mga examiner may tendency kung ano yung mga latest Supreme Court decision, binabasa nila yan. So we will follow the reside. So yung sa reviewer ko, hindi ko ang sinite ko pa Chua Borse. I did not apply the variance rule because that is the Supreme Court decision. Pero tong reside, in-apply yung variance rule, no? He was charged of estapa, pero empleyado siya. The crime committed is theft, no? Tingnan ko lang kung ano oras na ha. At pero in-apply na Supreme Court yung variance rule. Now, magbibigay ako ng ng example ng kung ano yung pagkakaiba ng book ko dun sa mga old books, na? Hindi ko na i-identify lahat. Actually, napakarami. Kasi maraming mga principle dati na nasa mga libro, mga Regalado, Gregorio, etc. No? Pero because of the development, mga bagong Supreme Court decision, hindi na siya ganun ka-controlling. Kumbaga may problema na siya. Na? Pag binasa niyo yung book ko, pati reviewer ako, you will notice na ang dami talagang development. Kasi kada taon ang criminal law, iba-iba ang Supreme Court decision. So I will give you an example. Tapos gagamitin natin tong Chua Borse tsaka reside. No? Yon. Ito yung ano, adjaw. Ito yung adjaw, tsaka yung ano, adjaw tsaka Dominguez. No? Yung adjaw tsaka Dominguez, this is an old case yung US versus adjaw at saka yung US versus Dominguez. No? Dito muna tayo sa yung US versus adjaw. Medyo luma na to Kaya nga US No? US versus adjaw. Now, ganito yon in the case of US versus adjaw. Na he is nagtatrabaho siya sa custom no? Tapos sa custom siyempre merong bag doon, bag na no sa airport to Kinuha niya yung belt doon sa bag, nilagay niya sa drawer niya. So what is the crime committed? So the crime committed is consummated theft. Why? Kasi according to the Supreme Court, ang theft kasi taking the property without consent of the owner with intent to gain. Meron ng taking walang consent ng owner. Tapos merong intent to gain. No? Walang actual gain rito dito sa US versus adjaw. Bakit walang actual gain? Kasi kung halimbawa yung belt binenta niya, may actual gain na 'yon. O kaya maluwag yung ano niya, yung maong niya, ginamit niya. By using the belt, that is gaining. No? Kahit gagamitin mo yan, pampalo-palo mo dun sa, alam mo, nagalit ka sa girlfriend mo, pinalo-palo mo using the belt. That is gaining by using. Using is gaining No? Pero in this case, hindi niya ginamit. Nilagay niya sa drawer. No? Hindi pa niya nagamit. So wala pang actual gain. Pero can you consider the crime of theft as consummated? Consummated na siya. Why? Kasi in theft, what is important is intent to gain, not actual gain. Huh? Not actual gain. Now, dito tayo sa Dominguez. This is also an old case US versus Dominguez. US versus Dominguez ganito. Ano sa sales clerk sa isang store, no? So ina-assist niya yung mga bumibili, bili na kayo, sige. So pagka-assist niya, ang ano gagawin, ito binili mo, so amin na yung pera, dadalhin niya. Yung pera dadalhin niya doon sa cashier. No? Dadalhin niya sa cashier. Pero binulsan niya yung pera. No? Anong sinabi ng Supreme Court? Ang sinabi ng Supreme Court, the crime committed is frustrated estafa. Why? Kasi he received the property with the obligation to yung under trust, no? He received the property, then he misappropriated. Tapos instead na bigay niya sa cashier, he misappropriated. Kaso, this is not consummated estafa. Why? Kasi sa estafa kasi, basic ang rule sa estafa, dapat may actual damage. In this case, may intent to cause damage. Kaso walang actual damage kasi he was immediately apprehended. No? So he was convicted of frustrated estafa. Now, ang tanong, Itong Dominguez, Adjaw, tsaka Dominguez, makikita nyo to sa mga libro. Actually, mapapansin nyo, ang dami, sa mga libro, ang dami talaga mga abandoned principle dyan. Makikita nyo sa libro. So, okay pa ba itong Dominguez? Hindi na siya okay. Why? Kasi yung Dominguez case, mapapansin nyo, yung akusado, no? Yung akusado in the case of Dominguez, he is an employee. Ang possession niya is physical. And therefore, the crime committed is qualified theft, not frustrated estafa. Physical lang yun eh. Ay, tinan mo, sa Chuaborte, di ba bank teller, kinuha niya yung pera dun sa depositor, hindi niya binigay sa bangko. Sa Dominguez, kinuha niya yung pera dun sa customer, hindi niya binigay dun sa cashier. Anong pagkakaiba niya? Wala, di ba? But in both cases, sa Chuaborte, empleyado. Locson, empleyado. No? Yung Dominguez, empleyado yan. Hindi nila binigay sa company yung pera. So the crime committed is consummated theft. Pero despite of the abandonment, kumbaga despite of the fact that Dominguez case is not anymore controlling, that is not anymore frustrated estafa, that is consummated theft. Pero yung lesson behind the Adjaw and Dominguez cases are still there. Ano bang lesson? Tingnan natin yung lesson. Nagkataon, kung sakasakali that the crime committed talaga is estafa. Kasi hindi sa empleyado. Palagay na natin presidente siya ng bangko. No? So, magiging estafa na yon. No? Makikita mo pa rin yung principles sa Adjaw at Dominguez. Ano ba yung principles behind these two cases? Ito yung principle dyan. No? Sa theft, what is important is intent to gain. Actual gain is not unimportant for purposes of consummating the crime of theft. Sa estafa naman, no, intent to cause damage is not enough. Dapat actual damage. Ulitin ko sa theft, dapat intent to gain, okay na yan. Actual gain is not important to consummate the crime. Sa estafa, no, actual damage is important. Intent to cause damage is not enough. No? Kaya nga sa theft, pag kinuha mo, kahit na walang actual gain, kasi immediately nahuli ka. Consummated theft na yan. Pero kung talagang estafa siya, it so happens sa Dominguez, hindi talaga estafa yan eh. Kung talagang estafa siya, alam mo, presidente. No? Presidente. No? So, pagkakuha niya, later on, he was arrested. Merong intent to cause damage. But there is no actual damage kasi immediately he was arrested eh. No? Walang actual damage. And therefore, the crime committed is only frustrated estafa. Now, meron akong isang ibibigay na na technique sa inyo para malaman nyo kung special complex crime doctrine of absorption. Kasi may may technique yan eh. Minsan kasi there are several crimes. Will you consider these several crimes as one crime or separate crime? No? So in the process, i-lecture ko yung latest case ng yung People versus Espiritu, parang GR number 226-140, February 26, 2020. No? May papasok natin yung kaso na yon. Doon sa mga peers here, later on, kasi magko-complex crime kayo, so dapat maintindihan nyo kung special complex crime siya, complex crime, or you will apply the doctrine of absorption. Sa mga ibang na-lecturean ko na, ito, hindi ko pa na-lecture sa inyo to eh. Pero magpipreliminary muna ako para, saka tayo tumumbok, no? Pag halimbawa, maraming krimen, ano bang gagawin mo? No? So, titingnan mo muna kung special complex crime siya. Kung hindi, kung complex crime siya. Kung hindi, tingnan mo muna kung if you can apply the doctrine of absorption. Kung hindi, that is a separate crime. Na? Tingnan ko muna kung anong oras na, baka mamaya ano pa tayong 45 minutes, no? Kasi hanggang ano lang ako hanggang 5:30 lang. Pero mag question and answer tayo, no? Pero mag-preliminary muna ako bago tayo tumumbok doon. Technique yan kasi mapapansin nyo, lalo na sa mga Persian, pag nagbasa kayo ng criminal law, pupunta kayo sa complex crime. Napaka-complicated niya. Dito muna tayo sa special complex crime. Special complex crime. So, special complex crime is composed of several crimes where the law prescribes a single penalty. So, that is the essence of a special complex crime. Special complex crime. That is the singularity of the penalty prescribed by law, even if there are several crimes committed. No? Halimbawa ganito. Under Article 294 of the Revised Penal Code, nakalagay doon, if by reason or on occasion of robbery, homicide has been committed, the person guilty of robbery shall be punished by reclusion perpetua to death. So, ano napansin nyo? There are two crimes, robbery and homicide. Dalawa yan. No? And yet, there is only one penalty, reclusion perpetua, no? To death. So, ganun lang kasimple actually yung konsepto ng special complex crime. Dalawang krimen, isa yung penalty. Ganun siya, ganun kasimple yung special complex crime. Now, may tinatawag tayong complex crime under Article 48 of the Revised Penal Code. Kasi kung mapapansin nyo, merong complex crime sa Book 2. No? Book 2, such as rape with homicide, robbery with homicide, kidnapping with homicide. Meron din complex crime sa Book 1, sa Article 48. No? Ngayon, kaso yung article, pag binasa mo yung Article 48 of the Revised Penal Code, meron siyang official title, complex crime. Na? Meron din complex crime sa Book 2. So ang ginawa nila, yung mga writer tsaka ng Supreme Court, so as not to confuse complex crime in Book 1, Article 48 of the Revised Penal Code, from complex crime in Book 2, such as rape with homicide, robbery with homicide, they describe complex crime in Book 2 as special complex crime. Ganun po yon. Pag binasa mo yung RPCO, hindi mo naman makikita yung word na special complex crime. Inimbento lang yan ng Supreme Court tsaka ng mga writer. Ang intention ng Supreme Court tsaka ng writer to distinguish complex crime in Book 2, such as rape with homicide, robbery with homicide, from complex crime in Book 1, Article 48. So technical po yan. Pag sinabi mong complex crime, Book 1, Article 48. Pag sinabi mong special complex crime, Book 2 yan. Ganon. Now, yung complex crime sa Article 48, there are two. Yung compound crime, saka yung complex crime proper. Yung compound crime, that is delito compuesto. Yung complex crime proper, that is delito complejo. Na? Yon. Dito tayo sa compound crime. Compound crime is, di ba, that is composed of two or more grave or less grave felonies produced by a single act. So in other words, the essence of a compound crime is the singularity of the act, no? Although there are two or more crimes were produced by that act. No? So, alam mo ba ganito? Naman gago ka, pum, binaril mo ng ganyan, patay si Pedro. Yung bala, lumagos dun sa leeg niya. Tinamaan din si Juan. So that is a single act of pulling the trigger, producing two homicides. So that is a compound crime under Article 48. No?
Kasi ang sinasabi kasi ng batas, oo nga, dalawa yung krimen. Pero these two crimes were produced by a single act eh. So we will just consider these two crimes as one crime. So we will merge these two crimes together to form one crime, and we will call this one crime as complex crime. Na? Ganun yun. Now, if the essence of a special complex crime is the singularity of the penalty, even if there are several crimes produced, yung essence naman ng compound crime is singularity of the act, even if there are several crimes produced. No? So pag single penalty, several crimes, special complex crime. Pag single act, several crimes produced, compound crime. Ayun ang pagkakaiba nyon. No? Now, dito tayo sa complex crime proper. Sa complex crime proper, this is composed of several crimes, one or some of which is a necessary means to commit the principal crime. Halimbawa ganito, meron kang gustong lokohin, si Pedro, no? Para maloko mo siya, pinalsify mo yung cheque. Hindi ka naman abogado, you're not aware that in falsifying a check, that is already falsification of public documents under Article 172. Then you use the falsified check, pare, pautang ng pera, ito, i-check ng company, to defraud Pedro. Huh? So in using the check to defraud Pedro, that is stop under Article 315. Ngayon yung kakasuhan ka na, sabi nung abogado mo, at ang kaso mo dalawa, estafa at falsification. Attorney, nagulat ka. Bakit dalawang kaso ko? Isa lang naman ang gusto kong mangyari. Gusto ko lang naman lokohin si Pedro. Bakit biglang ang kaso ko dalawa na? Parang unfair naman ata yan. Na? So, may punto yung kriminal. Kumbaga, although criminal siya, dapat ikulong yan, pero wag naman dalawa, isa lang naman ang intention niya. Kaya ang ginawa ng batas, oo nga, no, sabi ng batas, merong punto. So, sabi ng batas, kasi lumalabas that there is only one intention, and that is to defraud Pedro. And he merely commit falsification of public commercial documents as a necessary means to commit estafa. So sabi ng batas, isa lang naman ang intention niya. So we will just treat these two crimes as one crime. We will merge these two crimes together to form one crime, and we will call that one crime as complex crime or complex crime proper. No? Ayun. Kaya isa na lang siya. So in other words, yung essence and special complex crime is singularity, no? Hintayin yung mga iba rito, napakinggan na yung lecture ko, pero wait lang kayo kasi yung espiritu case, very very interesting yon. Mamaya pupunta tayo doon kasi nagpe-preliminary lang muna ako, ha? Kasi yung iba kasi nakikinig na ng lecture ko, sir, napakinggan na namin yan. Kaso nagpe-preliminary kasi hindi ko pwede dumiretso doon sa espiritu ng walang preliminary. No? Pero very interesting po 'yon. At baka itanong sa bar 'yon. Na? Baka itanong, very interesting. So 'yon. So if the essence of a special complex crime is singularity of the penalty, although there are several crimes committed, the essence of a compound crime is singularity of the act, although there are several crimes produced. The essence of a complex crime proper is singularity of the criminal intention. There is only one intention. So in a complex crime of estafa through falsification, the intention is merely to defraud Pedro. But in the process of defrauding Pedro, he committed two crimes, falsification and estafa. Now, sa special complex crime, hindi po required na a single act will produce two crimes. Hindi po required yun. Required lang yan sa compound crime. Pero actually, pwede mangyari yan. Nire-rape mo yung biktima. Medyo malaki yung ari mo, habang nire-rape mo yung biktima sa sobrang laki, inatake sa puso, namatay. That is a single act. No? That is a single act producing rape and homicide. And under Article 266-A, B of the Revised Penal Code, that is a special complex crime of rape with homicide. Single act. Na? Pero sa special, no, that is a special complex crime. Pero sa special complex crime, hindi po required yung singularity of the act, ha? Pwedeng rapin mo muna, tapos after raping, saka mo patayin. Pwede yan. So, no? So the act of raping is different from the act of stabbing the victim. And yet, that is a special complex crime. Kasi what is important under Article 266-A and B of the Revised Penal Code is that there is only one penalty. If by reason or on occasion of rape, homicide that's been committed, there is only one penalty. No? Now, the special complex crime, hindi po required that a component, secondary component, is a necessary means to commit the principal component. Pero pwede po yun. Pwede naman yun. Halimbawa, nasan yung jewelry? Ituro mo. Konti, tatanggalin ko panty mo. Ayaw mo. Tinanggal yung panty. Nasaan na? Ayaw mo. Papasok ko to. Ayaw. Sige. Pinasok. Habang nire-rape. Yun. Andun na sa aparador. Yun. So this is a situation where rape is a necessary means to commit robbery. So this is a special complex crime of robbery with rape. Robbery with rape po yan. Pero actually, hindi po siya required. You rape the victim, so robbery is not a necessary means to commit rape. Neither rape is a necessary means to commit robbery, and yet that is a special complex crime. Why? Because under Article 294 of the Revised Penal Code, is if by reason or on occasion of robbery, rape has been committed. Robbery is accompanied with rape, so that is a special complex crime. Ayun. Now, meron bang anong oras na? Meron pa tayong magpa-5 siguro, mag-15 minutes pa ako rito, tapos mag-question and answer tayo. So, pero at least aabutin natin yung espiritu. Binanggit ko na yung GM number ng espiritu, ha? Napaka-importante yun, ha? So, as a general rule, the components of a special complex crime are all consummated. Ganun po yun. That is the general rule. Halimbawa ganito, there are several crimes committed. Maraming krimen. Pero yung iba hindi siya consummated. Magduda ka na dyan. Mukhang hindi siya special complex crime. Why? Because as a general rule, the components of a special complex crime are all consummated. There are only two exceptions. And that is attempted rape with homicide under Article 266-A, B of the Revised Penal Code. Attempted rape with homicide. And attempted robbery with homicide, Article 297. So, dalawa lang po yan. I-memorize nyo kasi dalawa lang exception. Attempted rape with homicide, attempted robbery with homicide. Huwag nyo pong pagbabaliktad din, ha? Wala pong rape with attempted homicide. Walang robbery with attempted homicide. That is not a special complex crime. So, yung secondary components, palaging consummated dyan, walang exception. What is attempted is the principal components. Attempted rape with homicide, attempted robbery with homicide. Now, pag binasa mo yung Article 297 of the Revised Penal Code, makikita nyo meron doon attempted robbery with homicide and frustrated robbery with homicide. Wala na pong frustrated robbery with homicide. Wala na po. Why? Kasi wala nang frustrated theft, eh.
Pag wala ng frustrated theft, it follows na wala ng frustrated robbery. Because the concept of theft is the same as that of robbery. And that is taking without consent. The only difference is that in robbery, merong force upon-thing, merong violence or intimidation. Sa theft, wala. So pag walang frustrated theft, wala nang frustrated robbery. Kung minsan kasi sa mga libro, may makikita pa kayong frustrated robbery with homicide. That is not anymore controlling. Now, bakit wala nang frustrated theft? So it follows na wala na din frustrated. Mag-discuss ako ng dalawang principle. Yung unang principle na i-discuss ko sa inyo. This is the case of Laurel versus Abrugar, GR number 155076. January 13, 2009. Pag nagbabasa kayo ng mga libro, siyempre except yung book ko, mapapansin nyo sa mga book, halos lahat ng mga book, nakalagay doon that asportation consummates the crime of theft. That is wrong. Why? According to the Supreme Court in Laurel versus Abrugar, alam mo, asportation is an element of larceny, which is a common law crime. Larceny, that is equivalent to theft in the Philippines. Sa common law country, ang tawag nila larceny. Pero sa Philippines, tawag nila theft. No? So, ang asportation kasi, that is carrying away. Meaning, to consummate the crime of larceny, pagkakuha mo, tatakbo ka. Pagkakuha mo, tatakbo ka. Carrying away yon. Now, according to the Supreme Court, if you will read Article 308 of the Revised Penal Code, this is the provision that defines theft. Ang nakalagay doon, shall take, hindi naman shall take away, shall carry away, shall run away. Asportation is not mentioned in Article 308 of the Revised Penal Code in defining theft. No? Bakit, di ba? Bakit asportation? Bakit carrying away? Hindi naman nakasulat yun sa Article 308. So I will give you one example. This is the case of People versus Mercado, GR number 45471-72 at June 15, 1938. So, yung pulis kasi natulugan na mukhang pickpocketer to, so inobserbahan. Pagkakuha ng wallet, he was arrested. So nagkaroon ng argumento, this is not consummated theft kasi walang asportation eh. He was immediately apprehended. Walang carrying away, walang running away, walang taking away. Sabi ng Supreme Court, asportation is not an element of theft. So kung may doon sa mga libro na nababasa nyo, andun pa nakalagay doon, asportation consummates the crime of theft. That is wrong. Hindi po siya controlling, no? At so yun, settled. Kaya nga mapapansin nyo, ang malabo magkaroon ng frustrated theft kasi pagkakuha mo, consummated. Pag di mo nakuha, but alimbawa, kinukuha mo yung wallet, medyo masikip yung lonta ng complainant. Kinukuha mo wallet ko, arrest. Gago ka. Arestado ka. Yun. Hindi niya nakuha. Attempted. So, paano magkaroon ng frustrated? Pag nakuha niya, consummated. Pag hindi niya nakuha, attempted. Di ba? Now, isa pang example. Tayo yung People versus Valenzuela, GR number 160188, June 21. June 21. 2007. Na? Bago tayo mag-Valenzuela, babanggitin ko muna yung Dinyo. Itong People versus Dinyo, nasa mga libro pa yan, ha? May problema na naman yan. So, in the case of People versus Dinyo, according to the Court of Appeals, if the goods are bulky and the bulky goods were taken in a compounded phase, no? Oras na ba? May time pa tayo. To consummate the crime, it is important for the accused to bring out the property from the compound. Failure to do so, the crime is only frustrated theft because of the inability to freely dispose the property. Wala daw ability to dispose the property. Inabandon na Supreme Court yan in the case of Valenzuela. No? Bakit inabandon ng Supreme Court? Anong nangyari sa Valenzuela? Nangyari to sa SM Norte. Tide, dinakaw niya sa department store. Nilagay niya na dun sa kotse. Nasa parking area. So hindi niya nailabas sa parking area, he was arrested. So the defense is now invoking the Dino principle. Walang ability to freely dispose the property, na? Kasi hindi pa nailalabas ng parking area. So dapat frustrated theft lang. Alam mo, sa totoo lang, yung CA, nag-iimbento lang yan eh. Parang walang ability to dispose the property. Benta mo sa loob. Pwede naman yun eh. O kaya maghugas ka ng kamay, maglaba ka doon. Tide yun eh. Oh. Hindi mo ba na-dispose yun? O kaya, bilhin na kayo ng Tide. Oh. Mura to, 50% discount. Oh. Parang walang ability. Pumunta ka sa CR, gamitin mo yung Tide, maligo ka. Di ba? Are you not disposing? Kung alam mo, ninakaw mo pagkain, kainin mo sa loob ng kotse yung pagkain. Bakit kailangan mo pa ilabas ng bahay, ng mall, ng parking area to consummate the crime? According to the Supreme Court, the Supreme Court expressly abandoned the Dino principle. No? Bakit? You read article yung 308 of the Revised Penal Code, no? You cannot find the word ability, the phraseology of ability to freely dispose. That is not mentioned as an element. What is important is taking without consent. Tapos may intent to gain. No? At saka, importante gaining. No? Meron kang intent to gain. Later on, bibenta mo sa labas. No? Hindi ko, kahit ako hindi ko maintindihan kung saan na, ano tong principle na to, ba? Ability to freely dispose. Ano yun? Wala naman sa kodal yun eh. No? So that is the reason why the Supreme Court expressly abandoned the Dino principle. And sabi pa ng Supreme Court, there is no frustrated theft. Kasi once there is taking with intent to gain, that is consummated theft. You don't have to bring that property outside the from the mall, no? Outside the mall. Hindi na kailangan ilabas ng building ng bahay to consummate the crime. No? Consummated na siya. Sinabi ng Supreme Court, walang frustrated theft. No? So, kung walang, another example, in the case of People versus Salvilla, no? GR number 86163, April 26, 1990. 1992 O ang nangyari dito is that nasa loob ng compound Hold up to, may na yung pera. Papalabasan sila ng compound, dumating yung mga pulis. Hindi na nailabas yung ninakaw nila. Now, ang argumento ng defense, frustrated robbery kasi hindi na ilabas ng bahay For obvious reason, the accused is using the Dino principle as an argument. As early as 1990, the Dino principle is not anymore a good principle. Why? It was rejected in the case of Salvilla. No. Ability to freely dispose the property is not an important element of robbery. That is not mentioned in Article 294. Wala naman nakalagay doon Hindi mo na kailangan ilabas, consummated na yan. No? So, okay na tayo dyan. No? So, dito tayo sa, ito na yung, para ma-election na natin yung espiritu. No? Alam mo ito kasi classical theory tayo. Alam mo sa classical theory, meron kang human free will. No? To kill or not to kill. To act as a lookout or not to act as a lookout. To rape or not to rape the victim. Meron kang human free will Pwede mo naman di gawin, ginawa mo pa rin. Kaya sa classical theory, napakasama mong tao. Meron kang human free will not to do it. But just the same, you committed homicide. You committed rape. You conspired with one, in killing the victim. No? Kaya sa classical theory, ang importante talaga yung mens rea, yung criminal intention mo. Tinitingnan kung gaano ka kasamang tao. No? Kaya alam mo sa mga halimbawa, there are several crimes committed. Alam mo, ito general rule to Pag maraming krimen, hindi automatic na yan na nagiging paramihan ng krimen, hindi. Kasi tinitingnan ng batas yung criminal mind niya. Ano ba yung iniisip niya? And on the basis of that criminal mind, he will be penalized. No? Ano ba yung principal criminal mind niya? Kasi halimbawa, ni-rape, no? Sinampal-sampal mo, puta, gago ka, tanggalin mo yung panty mo, sinuntok-suntok mo ng kayo, papatayin kita. Pinunit mo pa yung panty. No? Ang kaso mo ba, rape, physical injury, threat, at saka malicious mischief by destroying the panty? Hindi ganun ang criminal law. Kasi tinitingnan nyo, ano ba yung criminal mind nito? Rapist to. Rapist to. So the crime committed is rape. Yung mga ibang krimen will be incidental na lang yan. Physical injury, threat, malicious mischief. Kasi these crimes were committed for purposes of implementing his criminal mind, and that is to commit rape. No? Paano mo marirape yan kung may panty yan? Kaya mo bang rape may panty? Sa akin mo yung panty. No? Kaya ang mapapansin nyo, ang criminal law, kahit na maraming krimen, as a general rule, nagiging isa lang yan. No? Why? Kasi maraming provisions that will consider several crimes as one crime, such as special complex crime doctrine of absorption. So, ganito yung technique. Halimbawa, maraming krimen. No? Tingnan mo muna kung special complex crime yan. Kung hindi, punta ka muna sa Article 48, baka compound crime or complex crime proper yan. Pag hindi pa rin, tingnan mo muna, baka applicable yung doctrine of absorption. Kung hindi pa rin, kung hindi sa special complex crime, hindi sa compound crime, hindi sa complex crime proper, doctrine of absorption is not applicable. Doon lang magiging separate crime yan. May mga time na pwedeng mag-separate crime, pero bibihira po yon. Ang technique niyan, no? Uunahin nyo yung special complex crime. Kung hindi, compound complex crime proper. Kung hindi pa rin, tingnan mo muna yung doctrine of absorption. Kung hindi, separate. Pero in that order, priority po ang special complex crime. No? Pumapangalawa yung complex. Priority ang complex crime naman over doctrine of absorption. Pag hindi pa rin, saka mo i-apply yung doctrine. Kung wala pa rin, separate crime. Now, in that order, in that order. Halimbawa, ganito. People versus Rojas, Jan number 172604, August parang 2010, Ponentes, Justice Peralta, na Rojas. So, he was abducted. Tapos, in the course of detention, binaril para patayin. Kaso, hindi alam hindi namatay Frustrated murder. Now, so, dalawa yung krimen. Kidnapping, tsaka frustrated murder. So, ang technique, tingnan mo muna kung special complex crime siya, complex doctrine of absorption. Dito muna tayo sa special complex crime. Pero, can you consider that as kidnapping with frustrated murder? Di ba sinabi, ano general rule? Ang components ng special complex crime are all consummated. There are only two exceptions. Attempted rape with homicide, attempted robbery with homicide. So, walang kidnapping with frustrated murder. So, that is not a special complex crime. Tingnan mo muna kung complex crime proper yan. Yes, according to the Supreme Court, since kidnapping is a necessary means to commit frustrated murder. Therefore, this is a complex crime proper of
frustrated murder through kidnapping. Na? Iyon. Yan. Now, di ba binanggit ko sa inyo yung people versus spiritu, binanggit ko na yun. This is a very interesting case. Alam mo, in the course of robbery, namatay yung biktima. So, robbery with homicide. That is a special complex crime. Wala tayong problema doon. Ngayon, halimbawa hindi namatay yung biktima. Pero merong physical injury. Alam mo, simple lang yan. Kahit pag may physical injury, the crime committed is still robbery. Why? Kasi for obvious reason, you will inflict physical injury as a necessary means to commit robbery. Mapapansin mo yung Article 294, robbery, tapos pag may physical injury, lahat ng form ng physical injury, slight, serious, less serious, etc., andun na. So in other words, pag may physical injury, in the course of robbery, anong title ng crime? Robbery. Pero halimbawa yung physical injury is not a necessary means to commit robbery. After committing robbery, nakuha mo na yung wallet. Tapos papalis ka na, parang nababad trip ako sa'yo. Binalikan mo pa. Hindi, sir, hinold up nyo na ako. Hindi, nababad trip ako. Sinunsuntok-suntok mo pa, di ba? So, yung physical injury is not necessary means to take the property, di ba? Hindi na siya necessary. What is the crime committed? That is robbery with unnecessary violence. That is also covered by Article 294. So, wala tayong problema pag may physical injury. Untitled robbery, kung unnecessary yung violence was employed, which is not a necessary means to commit robbery, you can describe the crime as robbery with unnecessary violence. So, okay na tayo doon. Pero ito yung sa espiritu. Halimbawa ganito. Merong robbery. May physical injury. Kaso yung physical injury may intent to kill. Iba ang rule. Bakit? Pag yung physical injury, merong intent to kill, yung infliction of physical injury with intent to kill, that is attempted, frustrated, homicide, or murder. Now, ang tanong, special complex crime ba siya ng robbery with attempted or frustrated homicide or murder? Wala. Bakit? Di ba, in-explain ko anong general rule natin. Ang special complex crime, consummated lahat yan, ang components. Dalawa lang exception. Attempted rape with homicide, attempted robbery with homicide. Ito, robbery with attempted homicide, baliktad siya. So, walang robbery with attempted homicide, with frustrated homicide, with attempted murder, with frustrated murder. Wala. So, that is not a special complex crime. So, kung hindi siya special complex crime, punta tayo sa Article 48. Ito yung sinabi ng espiritu case. If attempted or frustrated homicide or murder is a necessary means to commit robbery, this is a complex crime proper. On the other hand, if attempted or frustrated homicide or murder is not a necessary means to commit robbery, that is a separate crime. Sir, paano mo malalaman kung necessary o hindi siya necessary? Hindi in-explain ng Supreme Court, kaya ako na lang ang mag-i-explain. Kung halimbawa, you are committing attempted, frustrated, homicide, or murder for purposes of taking the property, putang ina mo, papatayin kita! Ayaw mo ibigay, ha? Papatayin kita. Ganon. So, yung attempted or frustrated homicide or murder is a necessary means to commit robbery. That is a complex crime. Article 48. Pero kung halimbawa ganito, nakuha mo na yung wallet, nakuha mo na. Parang nababad trip ako sa'yo, papatay na lang kita para walang witness. Pinatay, sinaksak mo, kaso hindi siya namatay. Can you consider the attempted or frustrated homicide murder as a necessary means to commit robbery? Not anymore kasi the robbery is already completed. In fact, meron ng taking eh. Ang he committed yung attempted or frustrated homicide or murder as a means to to eliminate the witness. No? So, magse-separate crime po siya. Magse-separate crime. No? At, yon. Ganun po yon. So, maiksi na lang to ha. At bibilisan ko na lang para makapag-question and answer na lang tayo. Halimbawa, ang pinag-uusapan is attempted robbery. Hindi niya nakuha yung property. Attempted robbery. Di ba pag may namatay, that is a special complex crime of attempted robbery with homicide, Article 294 of the Revised Penal Code. So wala tayong problema dyan. No? Now, halimbawa, merong hindi namatay yung biktima, pero may physical injury. Pwede ba siyang, no? Pwede bang yung physical injury magkaroon ng complex crime of attempted robbery with serious physical injury? Pwede. Why? Because of the case of Villanueva. Na? Villanueva. Bakit ganon? Dito, i-compare muna natin yung robbery sa attempted robbery. Dito muna tayo sa robbery. Di ba in-explain ko kanina sa inyo, pag robbery, consummated robbery, tapos may physical injury, pag necessary siya, robbery lang yan. Pag unnecessary siya, robbery with unnecessary violence. Bakit ganon? Kasi sa Article 294, ang daming provision yan na kinovered lahat ng physical injury, serious, less serious, at saka slight physical injury, pati unnecessary violence, covered ng Article 294. Pero sa Article 297, sa attempted robbery, wala. Meron lang doon attempted robbery with homicide. No? So, and that, so in other words, walang treatment yung attempted robbery, tapos may mga physical injury, walang treatment eh. And that is the reason why, na in the case of Villanueva, pag yung physical injury is a necessary means to commit attempted robbery, sinusuntok mo, tangina mo, ibigay mo yung wallet, ayaw talaga ibigay. So, hindi injury. So, that is a complex crime. Na? Complex crime of attempted robbery with homicide. Pero pag consummated yung robbery, hindi siya magko-complex crime. Robbery lang siya. No? Robbery lang siya. Kung unnecessary yung violence, robbery with unnecessary violence. Pero pag attempted robbery, iba ang rule. Pag attempted robbery, no, at merong serious physical injury, merong less serious physical injury, magko-complex crime yan. Pero pag slight physical injury, ina-absorb yan. No? Yon. So, wala na tayong time. Gagawa na lang ako ng write-ups on that. Alam mo ang criminal na napaka-complicated. At wag po kayo magagalit sa akin na si judge naman pag nag-lecture parang kino-complicate niya yung lecture. Hindi ko po kino-complicate, jurisprudence po ako. Talagang complicated lang talaga yung mga Supreme Court decision. Ang ginagawa ko lang, mapansin nyo sa mga libro ko, kinukuha ko yung mga Supreme Court decision, pinagtatabi-tabi ko lang. No? At talagang complicated siya. No? Hindi na ako makapagdetalye, so question and answer. Kaso ang problema, magsasalita na si baka kakapusin na tayo eh. Pasalitain muna natin yung mga magti-testimonial. Tapos kung may time pa, okay naman ako mag-question and answer. Na? At Rex, pagsalitain muna natin sila kasi baka
Alright po. Alright, thank you. Thank you very much po for that very rich presentation, Judge Campanilla. We are very honored to receive such expert guidance, especially at a time when the study and practice of law have become more challenging. In behalf of Rex, allow me to congratulate you on yet another feather in your cap with the release of your books and lectures. Congratulations, Judge Marlo, and here's to more years of working together as stewards of legal education. All right, and now to tell us more about what makes the book an expert guide and a resource in the study of practice of criminal law, we are very honored to be joined by another legal expert who can best guide us on how we can use the book for an optimum learning. Let us all give a warm welcome to Attorney Irene A. Alcabilia, Bar Exam Top-Notcher 2014 Bar Examinations.
Attorney Irene.
Good afternoon, ladies and gentlemen. First of all, congratulations, Judge Campanilla, on the launching of your textbook in Book 1 of the Revised Penal Code. I think everyone close to me would agree if I say that criminal law was my favorite subject in law school, and it still is, actually. In fact, I chose to teach this subject the first time, and I'm still teaching it now. As a professor, I am very particular with my resources in criminal law, and have been very candid about using my old book from law school with personal updates from the recent laws and cases that I read. But when I read the book of Judge Campanilla, voila, it's a complete package. It is more updated and reader friendly. It's like reading a more updated version of my old book, complete with commentaries on recent and relevant laws and jurisprudence. I don't even need to read a lot of cases, and that could save me a lot of time considering my low workload from my regular employment. Judge, I will surely recommend your book to my students next semester. In closing, I thank Judge Campanilla and the Rex Bookstore team for having me today at his book launch. I wish Judge Campanilla continued success, that he would write more books for us to inspire more law students and lawyers alike to become abogado de Campanilla. Congratulations again, Judge Campanilla.
Thank you, Attorney Irene. At expert din sa criminal law yan kasi top-notcher at the same time, ever since he's teaching criminal law. At pag itong professor nyo, patay kayo.
Okay. Congratulations.
Salamat, Irene.
Thank you for the book.
Kasama ko siya sa University Asia Pacific. At sa mga inaalagaan ni Dean Noche. Kasi magaling.
All right, thank you very much for your kind words and for gracing this afternoon's event, Attorney Irene. Hearing your praises of the book gives us utmost pride for having been chosen and entrusted with the publication of this masterpiece. In the same vein, allow us to express our gratitude to you as well for being steward of legal education and of law practice yourself. At this point, we will now be hearing more about how the works of Judge Campanilla helped pave the way for young lawyers today. We begin with the book testimonial from Attorney Katrina Monica C. Gao, 5th placer, 2018 Bar Examinations. According to Attorney Katrina.
Parang malabo ah. Wala ba?
right, I think we have some technical difficulty. So before I read the book
malinaw na.
testimonial.
Yan, okay na.
All right. Okay, so according to Attorney Katrina, Judge Campanilla's book is the definitive guide to criminal law and was especially helpful to me during the bar. His work is both concise and comprehensive and captures everything one would need to know to be ready for the criminal law bar exam. His explanation of penalties in particular is easy to follow but clear, perfect for those confused. Right, and now let us all welcome our another legal expert who we are very honored to be joined by for this gracing this event. Let us all welcome Attorney May Dayan Azores, Bar Exam Top Notcher 2019 Bar Examinations.
Magaling yan, si Attorney May.
Ayan. Hello, good afternoon, Judge Campanilla, and to all the law students present. Ayan, I'm very honored. Ayan, I'm very honored that I'm invited to give a testimonial about Judge Campanilla's book. And sabi niya, i-mention ko lang daw na pogi siya. So, ayan. Aside na maganda yung book, ayan, pogi po si Judge Campanilla. Ayan, Campanilla's book at the same time that I met him personally. I don't know if you remember, Judge, but you graced us with your presence sa school namin, sa UST Legazpi. Pumunta ka for a lecture. So, nung time na yon, first time ko ma-meet si Judge Campanilla, and I was really so amazed with how he discussed kasi wala siyang anything, and then memorize niya yung not only the case title but also the GR numbers. Sabi ko, grabe, ang galing memorize the GR numbers. So I thought that he was a genius talaga ever since. Kaya yun yung perception ko kay sir. So I immediately bought his book. So yung dalawang libro, meron kasi nun sa Rex Bookstore, binili ko agad. Sabi ko, talagang magaling na mag-lecture, so for sure magaling yung libro. So ayan. And then I added you on Facebook, sir. I was still a law student then. And then I understood, or I came to know about your story na that you had difficulties as before joining law school, ganyan, and then you encountered them. So I was more amazed with how you overcome those adversities. And then going back to the book, so I was on my 4th year then. So criminal law review na talaga. And the only reference I had during first year nung criminal law, yun yung, syempre, Reyes, yun yung mga usual na ano eh. And sabi ko, for the review, it's not possible or it's not wise that I review or read those annotated books again because they are thick books. So I was really happy that I bought those criminal law reviewers, yung dalawang books yan, book 1 and book 2. And then when I read it, sabi ko talaga, this is everything I need. I'm not kidding because for each subject, I chose at least 2 reviewers. But for criminal law, I only have Judge Campanilla's book. I only read it twice during the review. Okay na ako. And yun na, supplemented it with siguro lectures from the review centers, pero wala nang ibang kahit anong reviewers. Golden Notes, San Pedro, wala na, yun na lang talaga. Yung libro ni Judge Campanilla. And for everyone who asked me, kahit yung mga nagtatanong sa akin sa social media accounts ko, alam naman nila yun that I'm not kidding. Yun lang talaga yung nakalagay kong suggestions. And for yung ibang subjects, may mga binibigay ako at least 2 na mga reviewers. Pero for criminal law, I will only suggest Judge Campanilla's book because it's comprehensive, it's simplified, it contains previous bar questions and answers, and it also includes possible bar questions. And aside from that, it's comprehensive but summarized. So yun yung maganda doon. So kaya mo talaga siyang ulitin kahit twice. Even with the limited time in the review. So kahit twice mo yun basahin, paulitin mo, okay ka na doon. So ayan. So for all the law students listening and for all the bar reviewees, so I will put my name on the line here and my reputation when I say that Judge Campanilla's book is all you need. Thank you.
Salamat na attorney. Na-touch naman ako sa sinabi mo.
Thank you, Renzo. Thank you.
Thank you very much, Attorney May. Thank you for gracing this event, Attorney. And now I will proceed with the remarkable book testimonial of our young lawyers today. So for Attorney Markley Natuel, criminal law has always been a personal Waterloo. This field of law is just too complex for me, especially considering the endless. Also, I honestly think that my mind is just too innocent to comprehend even the smallest form of immorality, which may be the reason why studying criminal law has left me with more questions than answers. Campanilla, however, through his books and lectures, has given me the opposite, that is, answers to my numerous questions and even more answers to my already answered questions. He answered all my whys, all my what ifs, and even those questions that I would never think I would ask were in it not for my overly imaginative mind. I highly recommend his must-read book for those who are otherwise wanting to know how to get away with murder. For Attorney Mark Javier B. Oyales, second placer, 2014 bar examinations. Criminal law is one of the most challenging subjects in law. Unlike other commentaries on the subject, Judge Campanilla's criminal law reviewer offers a brief, concise, and reader-friendly reference material which speaks volumes of his mastery of the law. His holistic, methodical, and insightful approach to the subject matter proved advantageous during my bar review and even now as a teacher to future lawyers. From Attorney Jefferson L. Gomez, 8th placer, 2016 bar examinations. I wish to extend my congratulations to Judge Campanilla for another momentous achievement, lauded self-authored book on the Revised Penal Code of the Philippines. Without a doubt, this new edition will carry on the standard of positively conditioning and molding the aspiring lawyers in our country, as well as keeping our panieras constantly refreshed and abreast with the developments both in law and jurisprudence. To Judge Campanilla, may you continue to be instrumental in the law profession and remain steadfast and imparting your wisdom and expertise to the widest audience conceivable. All the best. From Attorney Catherine T. Ting, 8th placer, 2018 bar examinations. Campanilla's criminal law books for the bar and even attended his lectures. I must say it has been one the better decision. From Attorney Karen May L. Calam Ibanez, bar exam top-notcher, 2019 bar examinations. I have to admit, I have nothing but admiration and respect to Judge Marlo Campanilla, as he did an excellent job in explaining the concepts of criminal law clearly, comprehensively, and concisely, which only a person as well has been instrumental, in my case, in acing the 2016 bar exams and convert my weakest subject into my highest graded subject in the bar. From Attorney Anne Margaret E. Momongan, 7th placer, 2016 bar examinations. Judge Marlo B. Campanilla is one of the trusted reviewers for criminal law. Surely this book will be of great help to law students and reviewees alike to reach the dream of becoming a lawyer. And Alan Joel Pita, When I prepared for the bar, I really had a hard time with criminal law because of its inherent complexity of relating one given facts, and mastery of the laws is truly needed. And this makes criminal law one of the toughest barred subjects. Thanks to Judge M.D. Campanilla's books and bar lecture notes, his notes were concise, simplified, but comprehensive enough to cover everything. It was then a lot easier for me to identify and absorb the different doctrines and elements of the crimes, including their hairline distinctions. As the top law school says, to which I agree. After reading Judge Campanilla's books and notes, all of my questions were clarified. All right, so I think that's all for our book testimony. So at this point, Attorney, Judge, I will be reading the questions po.
Sige. Nasa ba yung sa chat, di ba?
Yes po, sa Q&A tab button.
Sige.
For first question, mga ilang books po, Judge, yung sa'yo for the bar exam?
Mga ilan?
Mga ilang books po, Judge, yung sa iyo for the bar exam?
Yung sa bar examination, Criminal Law Reviewer, Volume 1 and 2. Yung Criminal Law Reviewer, Volume 1, that is Book 1 of the Revised Penal Code. Pero ano yan correlation and discussion yan correlation with special laws, tsaka Book 2. Yung Volume 2 naman, RPC Book 2 yon. Pero correlations din siya. Kasi pag nag-lecture kasi ako correlations Ngayon, yung nila-launch natin ngayon, this is Revised Penal Code with annotation. Pang first year to. So, nag-iingat ako sa correlation kasi mga first year pa lang sila. So, kumbaga, mas ginawa kong mas simplify compared dun sa manner of writing ko sa reviewer. Kasi yon, siyempre magbabar na yan So, kumbaga alam na nila yung criminal law. Ito medyo simplify ko siya. Kasi pang persir, hindi ako magko-correlate lang ako pabalik. Paatras, hindi ako magko-correlate ng pasalong. So, yon. So, pag for purposes of the bar, palagay ko yun, okay na yung dalawa, kasi ganito kasi yan, pag magbabar ka kasi, medyo unless na speed reader ka, depende yan May mga iba kasi mabilis talaga magbasa Pero kung ano ka lang ang pagbabasa mo medyo ano lang, or you have no option but to be selective. Magiging selective ka sa pagbabasa mo. Kumbaga, pipiliin mo lang yung mga posibleng itanong sa bar, etc. So, tama-tama yung reviewer. Mas maganda to at saka, kasi yung mga professor, Reyes talaga yan So, kung ipiprescribe nila yung Reyes, maganda siguro after reading the book of Reyes, basahin mo din yung book. Kasi para magkaroon ng update. Para magkaroon ng update. Oo. Yun. Pero alam ko din sa mga ibang professor will already prescribe my book. Pero siyempre may mga prong naman nung iba, abogado, etc. Yun. Para sa akin, kung unless na mabagal ka magbasa, iba kasi mabagal magbasa Pero importante kasi yung updates at least para updated ka. Na? So ano pang tanong?
Okay po. Sir, good PM. Example, may isang reviewee na pumunta sa Mercury store dahil gutom siya. Pinili niya yung gusto niyang bilhin na pagkain, pero dahil gutom siya at madaming nakapila sa cashier na nasa loob ng Mercury store, is the reviewee liable for consummated theft? kahit wala siyang balak na hindi bayaran ang kinain niya sa loob ng store?
Babayada naman niya kasi yung ano yung intent to gain, pag binaliktad mo yan, in ano yan intent to deprive the owner of the thing. Owner, you are gaining. Halimbawa, merong Jollibee yung may-ari. Kinain mo yung Jollibee, no, yung hamburger. So, you are depriving the owner of that hamburger. And no, ngayon sa explanation mo, ang pinag-uusapan yan, meron kang to gain. Kasi kung halimbawa, bilyonaryo ka naman, pumasok ka doon, nagutom ka, kinain, kumbaga, intention mo, babayadan mo, after eating, niretain mo yung balot, yung ano niya, yung balot niya. Tapos, andun pa yung price tag na yun ang babasahin later on. So, that is not theft kasi walang intent to gain. Wala kang intent to deprive the owner of the thing. Pero, siyempre, that is a matter of evidence. Kung ipuprove mo yung, kasi kung halimbawa, pumasok ka ng 7-Eleven o ng Merco, gutom ka at medyo kumbaga, wala kang trabaho, etc. Tapos, yung kumain ka, nagtatago ka pa ng ganyan, sinimplihan mo. So, may ibig sabihin nyo, ang intention mo talaga is to deprive the owner of the thing. Pero kung alam mo, mayaman ka naman, hindi, mayaman ako, may pera ako, ito, babayadan ko yan, walang problema. At saka, ba't ko naman nanakawin yan? Laki-laki ng, kumbaga, ang dami ko naman pera. O, in fact, minintain ko nga yung hindi ko naman, kumbaga, kinain ko lang, pero babayadan ko siya. No? Kasi ando na yung taking Kaso wala yung intent to gain. Kaso yung intent to gain, that is something which is intent to gain. You have to present circumstantial evidence. So circumstantial evidence, one of which is that mayaman ka naman. So that is a circumstantial evidence that there is no intent to gain. Okay, wala kang pera, wala kang trabaho. Tapos yung kumakain ka, medyo tinago mo pa. Nagtago ka pa. O di halatang wala kang, tapos tinapo mo yung pambalot niya. So, ibig sabihin, wala kang intention magbayad. So, you are liable for theft. So, ano yan? Matter of evidence yan. Matter of evidence. So, ano pa?
We have another question. When will be the RPC Volume 2 be released?
Sinusulat ko na at hindi siya ganong kadaling tapusin. Talagang naasakit sa... Hindi nyo napapansin. Alam mo yung libro ni Luis Reyes, mga ano na yan, 16 magsulat. Kaya kumbaga, for 60 years, mapansin nyo yung libro ni Reyes, siya ang ginagamit na libro. Ang daming magagaling na abogado, pero they cannot produce a good book on criminal law. Napakahirap kasi gawin. Yung book to ginagawa ko na, kaso talagang time consuming yan tutulog ka ng 4 na oras, masakit sa mata, babasa. Kasi ako I have to trace the principle. Yung ano ba yung first time that this principle was crafted. Tapos from there minsan kasi nag-evolve yan, nagkakaroon ng modification, minsan nga nag-mutate pa yan Meaning, nag-iiba na yung principle, kumbaga nagkakaroon ng principle which is not contemplated by the ponente of the Supreme Court at that time that he crafted yung old principle. Nag-mutate siya, nag-iiba. Nabata ko lahat yan, pati yung Spanish text. May mga time lang naman na you have to read the Spanish text kung meron kang concern, kung meron kang dapat intindihin na parang hindi ka komportable. Titingnan mo yung Spanish text, you will read the book of Reyes, Regalado, Aquino, Gregorio. You will read Supreme Court decision. Ang sakit sa mata, sa totoo lang. Kaya nga ang advice ko dun sa mga kasi kami nagpapakamatay kami diyan eh. Sabi nga ni Elber Rebuya, a famous writer in civil law, no? Napakagaling niyan. Kasi why? Wala kaming ginawa kundi magsulat. Hindi ka makapunta sa SM, hindi kami makainom, hindi kami makapunta sa beach. Habang kayo nag-iinuman, nag-i-enjoy kayo sa mall, kami namin po yan, po natin isi-xerox. Kasi pinaghirapan po namin yan. Napakahirap, ang hirap isulat po niyan. Ano pa?
Diba, for our last two questions po, Judge, since we're running out of time na po. Clarification lang po sa attempted robbery. Pag may serious physical injuries, 2 crimes po ang i-charge.
Wala tayong problema. That is a special complex crime of attempted robbery with homicide. Pag hindi namatay, kahit may intent to kill yan o wala, titingnan mo lang kung necessary siya o hindi siya necessary. Kung halimbawa, you commit for purposes of taking the pain, agago ka, bigay mo na, tapos ayaw ibigay, tapos biglang dumating yung police na huli ka, hindi mo nakuha. So lumalabas yung physical injury, yung attempted, frustrated, murder or homicide, isa necessary ba? Yung may isa pang kaso yun eh. No? Pero kung slight, wala namang complex crime na pag slight physical injury, usually na-absorb yan eh. Kasi you have to employ violence in committing attempted robbery. Now, kung halimbawa, yung physical injury, attempted or frustrated, no? Homicide or murder, is not a necessary means to commit attempted robbery. Kung halimbawa, after ayaw mo ibigay. Sige, puta, sa'yo na lang yan. Hindi ko na kukunin yan. Bubugbugin na lang kita. Bubugbugin na lang kita. Tarantado ka. Ayaw mo ibigay. Sige, sa'yo na lang yan. Bubugbug. So, mapapansin mo yung physical injury is not a necessary means to commit attempted robbery. Kasi ayaw ko na nga yan. Sige, sa'yo na. Hindi ko na kukunin yan. So, that is a separate crime. Kasi separate siya. No? Pero iba pag consummated, ha? Pag consummated robbery, ganito ang rule. Pag may namatay, robbery with homicide, walang problema yon. Pag physical injury, tignan mo may intent to kill or walang intent to kill. Kung may intent to kill, no? So attempted, frustrated, homicide, murder. Pag necessary means to acquire the property, no? Kaya mo sa pinagsasaksak para patay, para makuha yung property, pero hindi siya namatay, complex crime yan because of spiritu. Pero kung halimbawa, nakuha mo na yung mag-witness ka pa, patay na lang natin to pare. Sinaksak ng ganyan, hindi naman namatay. So, separate yun because of the case of spiritu. No? Pero kung walang intent to kill, necessary means to commit robbery. Kung necessary means to commit robbery, the crime committed is only robbery. Kasi pag binasa mo yung Article 294, ang kompleto na yun eh, robbery. Tapos may kahit na anong klaseng physical injury, robbery pa rin yan. Pero kung hindi siya necessary, no, to commit robbery, no, robbery with unnecessary violence ang tawag doon. No? O kaya kahit na necessary siya to commit robbery, pero sobra-sobra naman nung kumbaga lupay-pay na 30 minutes na lupay-pay na siya, ba't mo pa susuntukin, di ba? So yun, robbery with unnecessary violence. Na? Yung espiritu, ingatan nyo, baka tanungin sa variant. Kasi bago yun. Bago. No? Wala kayong makikitang jurisprudence na ganun ang explanation. Ano pa? May tanong pa? O
For
okay na
our
tayo?
last question po, Judge.
Sige.
Any tips po, Judge, para ma-improve yung formulation ng thoughts para sa pagsagot ng bar exam?
Ano ulitin mo nga yung...
Any tips po, Judge, para ma-improve yung formulation ng thoughts?
Alam mo kasi, ang isang dahilan kaya mahirap pumasa sa bar examination kasi yung writing, you have to be a good writer. Alam mo yung writing, ano yan, inborn yan eh. May mga iba, yung, kumbaga, may mga iba talaga na may talent sa writing. Ito pagkabasa mo yung tanong at alam mo na yung sagot, may mga time kasi yung iba, parang excited, sasagutin na agad. Ako hindi ganun yun. Kahit pagkabasa mo ng tanong, kahit na alam mo na yung sagot, bigyan mo ng kahit na mga 5 seconds at i-compose sa mind mo, mental mind, paano ko ba titirahin to? Ang writing kasi, simple lang yan eh. So i-try mong sumulat, sumagot, tapos kumuha ka ng isang high school student, 3rd year. Ipabasa mo. Kung pagsusulat mo, ako pag nagsusulat ako ng libro, pinipili ko yung mga words ko, yung phrase ko, iniingatan ko. No? May mga time kasi yung pagsusulat na para maintindihan mo yung pagsusulat, i-connect mo yung first word sa last word na hindi maganda yun eh. Kailangan yung flow ng pagsusulat mo dapat pyramiding mag-start ka sa general statement, pabaksak sa ng ganyan. Pero ito lang ang basic kasi ito lang yung basic, no? Tapos na sentence, di ba? Magtawag ka ng high school, 3rd year, pabasa mo. Pag hindi niya nagustuhan, ibaguhin mo siya. Kumbaga, sagutin mo ulit. Kasi practice yan eh. Practicein mo, sagutin mo ulit. Ako pag nagsusulat ako ng yung libro ko, nasulat ko na, babalikan ko yon. Tapos, papaikot-ikutin ko na naman yung mga sentence, yung mga nirarambol-rambol ko yan eh. Hanggang sa lumabas yung maganda. Ganun din sa pagsusulat. Ano yan, practice? Practice yan. Ayun ang pinaka basta mag-start ka muna sa general statement, yung either yung batas o jurisprudence, tapos facts, tapos yung conclusion. No, pero may mga times sa bar direct to the point. Depende yan, case to case basis. Walang walang formula. May mga time na may sinasabi sila dapat 1 sentence or 2 sentence lang. Pero ako ang sasabihin ko depende pa rin. May time na kailangan mo ng 7 sentence. No? Yung iba may sinasabi dapat batas, jurisprudence, tapos facts, tapos conclusion. Maganda po 'yon. Oo. Kaso pag halimbawa sa criminal law, pag ang issue 5, dapat direct to the point. Case to case basis 'yan eh. No? Ako palagi pag nagsusulat ako, kaya bang intindihin to ng ordinaryong tao? Yun palagi iniisip ko. Pag naintindihan nila, ibig sabihin okay siya. Ganun din, i-test nyo. Pag yung pagkasulat, pag medyo yung iba, iwasan nyo yung nire-replace nyo o nire-reward nyo Pag nagbasa kayo ng batas at saka ng mga jurisprudence, hahanapan nyo ng mga yung mga tinatawag na keyword o phrase. Huwag nyo pong ibabaguhin yon. Kasi sa law, ang importante din sa law, memorization. Minimemorize nyo yung keywords saka yung key phrase. No? Yun ang importante. Huwag nyong babaguhin po yon. Baguhin nyo yung sentence, pero yung phrase, yung word, huwag nyong babaguhin. Halimbawa, yung People versus Simon, when the special law adopts the technical nomenclature of the penalty. So yung word, the technical nomenclature of the penalties, huwag nyong babaguhin yon. No? Pero pwede nyong baguhin yung sentence, pero yung technical nomenclature, no? Huwag niyong babaguhin. So instead of the law adopt, when the law use the technical nomenclature, pwede naman yun. So yung word na adopt, ginawa mong use, pwede. Pero yung technical nomenclature, huwag niyong babaguhin. No? Kasi mapapansin niyo sa mga Supreme Court decision, paulit-ulit na binabanggit yung technical nomenclature of the penalty. Actually, yung nomenclature, ano yan eh, name eh. Pwede naman when the special law use the technical name of the penalty of the Revised Penal Code. Pwede yun. Kaso, ang mga examiner kasi, hinahanap nila yung nababasa nila sa Supreme Court na natatandaan nila. Ang matatandaan nila ay technical nomenclature. Huwag mong i-rephrase. No? Ang bar examination, kombinasyon yan, no? Para makapasa ka, dapat nagme-memorize ka talaga. Kaya nga mahirap ang law, yung memorization. So, ano pa?
All right, Judge. Do you have anything more to say po before we end the program?
Salamat sa mga umaten at mag-aral po kayong mabuti at napakahirap po talaga ng bar examination. Kaming mga lecturer, mga reviewer, book writer, isa lang ang dahilan para matuwa kami, yung nakikita namin na pumapasa yung mga estudyante namin. Yung mga estudyanteng nagbabasa ng libro namin. Pag pumapasa, sir, abogado na ako. Ayun na, parang nanood na kami ng sine yun. O pumunta ng beach. Yun na yung kapalit ng sacrifice namin sa pagsusulat. Na? Good luck sana maging abogado kayo lahat.
All right, thank you very much, Judge. On that note, we have come to the end of this afternoon's program. Indeed, it was a very productive learning afternoon with our legal luminary, Judge Campanilla, and our distinguished guests from the field of law. In behalf of Rex, I would like to express